Legislative Committee meeting to order. We have a motion approving the minutes of the last meeting. Motion by Evelyn, second. All in favor? Aye. Opposed? Carried. Okay, the first item we have on the agenda is legislation. I think it's a resolution, actually. Seeking state assistance with the New York tax cap. And that was a resolution that's adopted by Essex County, referring to the tax cap, pointing out economic issues in the Adirondack Park, talks about the 2009 Regional Assessment Project, showing that real property tax as a portion of total revenue has decreased, and that there's difficulty doing economic development in the Adirondacks because of basically state land acquisition and Adirondack Park Agency regulations. And it asked for assistance from the governor's office and the legislature for infrastructure needs and regulatory relief. And then I believe, Martin, you drafted a revised version of that resolution?
I don't think so, no.
No?
I did?
Okay.
Did I? Can I, where, is that in my...
Well, there's a footnote.
When did I do that?
Revised version.
It was the one that Mr. Simpson was going to bring to the board meeting.
Okay. Which attachment?
It's attachment one, it's just the last,
Attachment one.
Oh, okay.
it's the last pages of attachment.
Yeah, I mean,
Yeah.
I reviewed it, but I didn't really revise it.
That's one that Mr. Simpson had, that they were gonna bring at the board
Yeah,
meeting.
okay.
So is it revised, or what? The scanning it looked to me like it was basically the same, but.
Yeah.
Yeah. What strikes me about the tax cap is that the state government imposes on local government a tax cap which is lower than what they increase the state budget, which seems to me kind of untenable. And I just raised the question whether we should include something like that in this resolution, or should we just draft an entirely new resolution? I don't know, is there any input from the committee? I think we're all concerned about the tax cap and its impact on local government.
Well, what I got from reading this is that they were asking for state financial assistance if you're in the Adirondack Park.
Right.
So, I mean, that's the bottom line, right? There's nothing wrong with that.
Yeah. Yes.
I think you're right, Mr. Chairman. I think it's unfair that the counties are asked to live by different rules than the state.
Right. Well, especially when the state is then imposing mandates on the counties.
That's exactly right. So I'd like to see some language in regards to that.
I think it may be more effective, if anything is effective, to do it as a separate resolution. Maybe pass this one and then do a separate resolution.
Sure.
Saying that.
However you want to handle it.
Yeah.
That's to me the key point.
Right.
They're asking us to live by different rules and they live by themselves.
You want us to live at .75 or whatever it is this year. And we live whatever you live with that year.
Well, we could just add language to it saying, we wish that you would amend the tax cap to say 2%, the cost of inflation, or whatever the state budget has passed, whichever is less.
Whichever is higher, right? Oh, yeah, whichever is less, right? These are cutting it.
Well,
Yeah.
I think we're all agreeing on that. My only issue with this particular resolution is it really hammers home on the Adirondack Park a lot, and while we do certainly have additional constraints and difficulty, I think this is a problem throughout the state. I don't think this is an Adirondack issue so much as a statewide issue. And I would certainly like to see us be equal to the state, so whatever they're doing, I think we ought to do, and not give them the option of, putting us at .73% or the rate of inflation, whatever the state's doing, it should, if it's good enough for the state, it should be good enough for the counties,
Mhm.
in my opinion anyway.
Right, yes,
So we agree with that, Queensbury's outside of the Adirondack Park.
yeah,
No, it's not, the whole northern half of Queensbury's in the Adirondack Park.
yeah,
Yeah, but a lot of Queensbury's outside of the Adirondack.
right.
And I
Mhm.
would agree with Evelyn that we should include the rest of, Warren County that is outside of the park. The same sorts of issues apply to us, even though we're not technically, Glens Falls isn't in the park, for example.
Mhm.
The same sort of issues apply to upstate that are areas outside of the park. So I would just include, areas of Queensbury that aren't in the park and Glens Falls.
So I'm not sure where we go from here. Do you want to pass this resolution as is and do a separate one, or just add something to this regarding keeping it the same as the state's? The percentage that the state increases the budget.
Well, do we want to include language in there that says that the municipalities in New York State should not abide by the tax cap if the, state legislator's not going to abide by it?
Yeah. Yeah. Matt, I think.
If I could, make a suggestion, I would like to see maybe two separate resolutions, because the Adirondack Park deals with a whole different, situation than the town of Queensbury outside of the park. We have more regulation within the park that impacts our ability to develop or become economically viable. I agree that it should be, but I think, Queensbury should be included, but in a separate resolution addressing it, in my
Mhm.
opinion. Or at least the part, the Adirondack Park covers part of Queensbury, half of Queensbury. But this resolution is, I think, built around the Adirondack Park and its challenges.
Right. Yeah, I mean,
There's a difference.
I feel there's two significant factors inside the Adirondack Park that don't apply outside. One is that's the target of all the massive land acquisition where we, acquired 1 million acres either in fee or in conservation easement in the last 15 years. And that's had a big impact on the economy because that's really taken off the table for economic development. And then the regulations of the APA, which you don't have in the rest of the state. So I tend to think it's appropriate to pass this resolution just with respect to the Adirondacks, and then do a separate resolution saying that the tax cap should be, actually, I feel it should be whatever the state legislature did the year before, that year, because they're passing their budget by April 1st if they're on time. And so we know what their budget is, so make that the tax cap for the coming year.
I agree with that.
Okay. So we make a motion to approve this resolution as drafted from the Essex County one then, and then a separate, well, let's do that one first. Did you make that as a motion?
Yes.
John? Seconded by Matt. Any further discussion? Hearing none, all in favor?
Aye.
Aye. Opposed? Carried. Then a separate resolution requesting the governor and the legislature to establish the tax cap at whatever the state increases, the percentage that the state increases the state budget the year before.
That's the tax
Yeah.
cap.
That's
Yeah.
tax.
Okay.
I'll-
Motion by John, seconded by Edna. Further discussion? Hearing none, all in favor?
Aye.
Aye, opposed, carried. Okay, now we have, again, I think it's a resolution rather than legislation adopted by Lewis County opposing the U.S. Environmental Protection Agency and U.S. Army Corps of Engineers expanded definition of waters of the United States under the Clean Water Act and supporting U.S. House of Representatives Bill H.R. 1732. And this has to do with, the EPA regulations, which, correct me if I'm wrong here, Martin, but I believe that until these recent, recent change in the definition, waters of the United States, which gives the EPA jurisdiction over waters dealt with navigable waters.
Right.
And I'm familiar with the U.S. Supreme Court case called Rapanos, I believe, versus the EPA, which basically challenged the EPA's attempt to regulate waters which are like 20 miles from navigable waters. And there were some other cases, and then EPA proposed changing the definition of waters of the U.S. to take out that navigability requirement, which leaves open the possibility that just small things like drainage ditches, and there's some examples in here, but things that are not really navigable water can be impacted, and that gives a lot of concern for farmers, and I think it's a concern also for local governments because of the work that you do on highways. So there's some federal bill, H.R. 1732, calls for the Secretary of the Army Administrator of EPA to withdraw the proposed rule, require the agency to develop a new proposed rule to define waters of the U.S., take into consideration public comments, reports, and all important joint consultation with and solicit advice represented state and local officials and stakeholders to reach a consensus. And there should be federal deference to state primacy in the development of water law and governance of water rights. So I tend to agree with that. Anyone else have any comment on it? Or Martin, do you have any comment on it?
You know, I think it's just sort of a preference policy determination for the committee here. I mean, the resolution would certainly oppose any expansion of the jurisdiction. So if that's your intention, then that's your intention. I think we've all heard of the concerns about the small property owners, the farmers. You know, is there a pond on a farm that you know, ultimately through a small channel or through a seasonal channel somehow leads to navigable water a few miles away, and all of a sudden now you've got the federal government having authority or control to regulate that pond. So I think it goes in part to the private property interests as well.
And also, you know, state control, because we have all sorts of state regulations on water, and would we rather have federal agents, you know, challenging us, or state agents? I think I'd prefer the state. But yes.
Fred, hasn't that been brought up at our APA local government by Herkimer County, our rep from Herkimer County, that she owns all that farmland?
Right.
It's just another layer of somebody, and they work with ag markets, or I think the less intrusion by government is better.
Right. Yeah, and there have been instances where EPA has even fought individuals who wanted to challenge their jurisdiction, you know, arguing that they didn't have the right to go to court to challenge the jurisdiction. One case I've read that says that. What's the pleasure of the committee?
I make a motion that we adopt the legislation supporting Lewis County.
Okay. Motion by Evelyn, seconded by Mark. Any further discussion? Hearing none, all in favor?
Aye.
Aye, opposed, carried. And then the third resolution is proposed by Supervisor Strauss, supporting New York State's 2017 suffrage centennial and the 2020 National Suffrage Centennial. Mobilize recognition of women during the year 2017 and now through 2020 to celebrate New York State National Suffrage Centennials. John, you want to talk about it?
Yeah, I mean, New York State was the first eastern state to to give women the right to vote. And, you know, on all your history books, we talk about the 1848 Seneca Falls movement. And with, Elizabeth Cady Stanton and Lucretia Mott. And Elizabeth Cady Stanton was born right here in Johnstown. And, you know, we in New York had a big impact on the women's suffrage movement here in New York. So, in 1917, we passed legislation in New York that gave women the right to vote. And so that centennial's coming right up. So, this piece of, this model resolution, which I just adapted it for Warren County's purposes, states, you know, that, you know, Warren County has a rich tradition, you know, artistic, literary, business, activist expression by women. And then New York State is considered the cradle of the women's rights movement in the United States. And in 2017, there's going to be a big centennial observance of the 1917 victory for women in New York. And this is just recognizing that, and it's also adding that, you know, we'll recognize and promote and help celebrate the 1920 adoption of the 19th Amendment, which gave women the right to vote universally in the states. So that's all this resolution is saying that Warren County is going to be proud of and promote the women's suffrage movement as we come to the centennial celebrations in 2017 and 2020.
Okay. Mark?
With that,
Moves it. Seconded. Any further discussion? Not, all in favor? Aye. Opposed? Carried. Okay, referrals, the committee tabled the matter requesting the governor and legislature to amend the New York State V&T law regarding designation of highways and travel by all terrain vehicles, referred to the county attorney requesting he provide an opinion whether or not this would provide towns with the authority to designate county and state roads as such. Or, do you have any opinion on this?
Did everyone get my memo of August 13, 2015 on this? So, it must have been some time ago that we met, because this was, we haven't had a meeting. Well, I mean, it occurred to me when I was preparing it, we haven't had a meeting, because this was my assignment for...
Back in June,
Yeah,
hopefully.
yeah. So, all right, well, we haven't met in a while, but in any event, did everybody get the memo? Does anybody have any questions?
Is that on drones?
Drones is coming up.
Oh.
Drones is coming up. This has
wait.
to do...
I'm going through the pile here.
Yeah, there's a lot. This has to do with the amendment to the New York State Vehicle and Traffic Law, and the question posed to me was whether or not the town,
We don't have a copy yet?
No, not yet.
I believe it was sent out to everybody.
Wow, I didn't know I was supposed to bring it.
Neither did I.
what did it say?
Okay, I'll just go to the, here's what I'll read. I do not believe a town has the authority to designate a county or state highway for travel by ATVs. The operative language in section 2405 of the Vehicle and Traffic Law is, quote, under its jurisdiction, close quote. The state or county highway would not be, quote, under the jurisdiction, close quote, of a town. Therefore, it would be up to the state to designate state highways and a county to designate county highways. In my view, a town would have no authority to designate a state or county highway as open for travel by ATVs to gain access to areas or trails adjacent to the highway. I note that section 2405 provides that any such designation by a town for town roads must be by local law or ordinance. In sum, because state and county roads are not under the jurisdiction of towns, a town cannot make a designation for those roads. No designation equals no liability. Okay?
Okay, and this came up in the context of a resolution which asks for an amendment of the Vehicle and Traffic Law, which currently says that towns can designate roads for travel by ATV where it's otherwise impossible to get from two segments of the trail.
Correct.
And so then somebody at this the meeting back in June asked, would that apply to county and state road, or county and, state roads?
I believe it was Supervisor Wood who asked the question.
Yeah,
We're
county and
concerned
state.
with the liability
Yeah.
issues.
Yeah,
We have a lot of problems in our town with people, they don't wanna go from trail to trail, they wanna drive on the road. And
Right.
a car comes up, I mean, these are not the same as a vehicle, there's no seat belts, they're not enclosed, there's often children on the back.
right,
And so, for a liability concern, often in our rural roads, there's no significant shoulder. So, people can end up in the ditch, these things can flip over, there could be accidents, and liability was a concern on my
Right.
part.
right. Okay, so that's the clarification or opinion on the impact on, county and state roads. Do we wanna take any action on the original request for the resolution, removing the language, otherwise impossible? Which frankly, I don't think there's much chance of the legislature ever passing that, but.
You're talking about removing language that currently prohibits ATVs from crossing county and state roads?
Well, as I understand it, in the B&T law, there's a provision that says that towns can designate roads to be used to connect two segments of a trail.
Their own roads.
Yeah,
Yep.
their own roads.
I
Where-
can read
Okay,
read the
yeah.
statute, I can read the statute,
Right.
and then maybe we'll have a better of an understanding of what the amendment is intending to. Vehicle and Traffic Law 2405 provides the New York State Department of Transportation, quote, with respect to state highways maintained by the state and any other governmental agency, with respect to highways, including bridge and culvert crossings under its jurisdiction, may designate and post any such public highway or portion thereof as open for travel by ATVs, when in the determination of the governmental agency concerned, it is otherwise impossible for ATVs to gain access to areas or trails adjacent to the highway. The resolution before the committee calls upon the state legislature to amend section 2405 to remove the, quote, otherwise impossible, close quote, language from section 2405. This would provide towns and counties with needed flexibility to open roads to adjoining trail systems and lands for completion of trails.
Right. So this is an important issue in St. Lawrence County where they're trying to build extensive trail networks in St. Lawrence County, and they've been able to do it in much of the county that's outside of the Adirondack Blue Line. And, but this they feel has been, an obstacle, both in and out.
But currently, you can make the request to the jurisdictional agency, whether it be state or county, to request that ATV crossing and show its necessity, right?
Or even a town.
Yeah.
A town falls under this too, I think.
Yeah, but
Yeah.
the proposed resolution was to amend the V&T law, that section Martin just read, to remove the otherwise impossible language, which would mean that the towns or the state or county could do it, whether it was otherwise impossible or not.
Essentially in their discretion.
Right.
So removing the otherwise impossible, finding that it was otherwise impossible, removing that, and now a town, through a local law, simply saying, this is what we're doing.
I think the state will agree to allow ATVs to cross its roads without it giving it the approval?
Well, I don't think it would change the fact you would still need approval from the state to cross or
Yeah, you
state roads.
still need that.
You still need it, but
still need that,
the
but-
criteria, but it would remove the element that you would have to show that it's otherwise impossible to get to a trail.
Right. So the town would no longer have to make that finding. The
Right.
county would no longer have to, with respect to town roads. The county would no longer have to make that finding with respect to county roads, state.
Just have to show a need for it.
Or
Presumably.
just a desire.
Just a desire, yeah.
Wouldn't even have to show a need anymore.
Okay.
Do we wanna support it or not?
I mean, I can support it.
Yeah. Mark?
support it. You know, it's a case-by-case basis.
Yeah.
A town sees it as an economic driver, and, you know, there may be another route, so they wouldn't be able to do it, but maybe they wanted to go by a street with some stores or something. You know, so I think giving the towns a flexibility.
Okay. So, would you make that motion, or John? John, will you make the motion?
Yeah, I'll make the motion.
Mark, you second? Okay, further discussion? Hearing none, all in favor? Aye, opposed? Okay, everyone's one no. Okay, then we're on to,
Help you though, wouldn't
again, I think this is a resolution forwarded by Rockland County regulating the use of drones pending a determination of whether other counties have enacted similar laws.
Was referred to me, Mr. Chairman?
Yep.
And here's what I did with the referral. I reached out to the sheriff's office, I reached out to Brian LaFleur, I reached out to Ross Dubari. I also reached out to our insurance carrier, well, not our carrier, our consultant, Lee Pollock. And, the materials that I handed out this morning are their responses, to me from each of their perspectives. There is some federal legislation that's out there proposed, and that's actually incorporated into Brian LaFleur's email. And there's some proposed FAA rules and regulations about drone use. Rockland County has taken a step to impose regulations with respect to drone usage in Rockland County. There are a number of concerns that are out there that are really readily, easily identifiable. And they are very neatly summarized in an article that appeared in Airport Magazine that Ross provided me. And I never want to make copies of this because I'm not sure about copyright laws, but in any event, you're all free to come to my office and review this. The article is entitled Unmanned Aircraft, a Benefit and Security Challenge at Our Nation's Airports. The author of the article summarizes what, in his opinion, are the three major risks, and he calls it a disturbing potential risks is the ability of these unmanned aircraft systems, UASs, to deliver dangerous packages. That's risk number one. Risk number two is it can be used for spying, invasion of privacy. Risk number three is just air traffic safety. I mean, we can imagine that. So, the Rockland County law pretty much goes on to prohibit these unmanned aircraft devices, systems, from being utilized near the Rockland County Airport. They can't be used near the Rockland County jail. They can be used for legitimate law enforcement purposes. They can fly over private property that you own. They can fly over private property of others, provided that you have the consent of that property owner. But this seems to me to be an evolving, developing area. The federal government is out there. They've proposed regulations. It may be by the time the federal government gets through with this proposal that any regulations or any local laws that we would enact would be superseded. But that's not to say that we shouldn't do something in the interim if we think that there is a need or a concern. On that point, here's what I propose. I wanted to hand these materials out to you today, give you an opportunity to digest them. If anybody wants to read this article, it's in my office. Anytime, just stop by. It's a very well-written article, and when I read it, I really came away with a better understanding of what these devices do and what risks they present to us. But my thought was we keep this on the agenda, Mr. Chairman, and we have a thorough discussion about this next time. You'll have an opportunity to review the materials. We invite the sheriff, we invite the undersheriff, we invite Ross, we invite Brian, and sort of we hear from them and collectively make a decision as to whether or not we want to adopt some local legislation similar to what Rockland County has done, or whether or not we want to wait to see what the federal government finalizes, or whether we want to do nothing.
Okay, is there any regulation now about using it near the airport? No, federal regulation, I haven't seen it.
If you look at Ross's memo, his memo of August 2021, he talks about the most prevalent issues that continue arise are regulation and enforcement. The proposed provisions in the FAA Small USA Notice proposed rulemaking will address many of the regulatory concerns. As a manager of a general aviation airport with Class G airspace, I have some additional thoughts that I would like to share. I think Ross would tell you that they're concerned about the use of these things at the Warren County Airport unregulated at this particular time. But I would like you to hear that from him.
Okay. So, the proposed, yes, but,
I don't know if this is fact or not, but I know when DEC was doing some video flyovers of the area, they were told that the producers couldn't go within 2 miles of the airport. I don't know if that's a fact or.
Well, what Ross writes, and this is a bit disturbing, as is currently proposed, these devices will not need air traffic control permission to operate at the Floyd Bennett Memorial Airport. Seems to me that that's something that we should look into and be concerned about.
so it sounds to me like, you know, there's a lot of issues, it's really evolving, we've got some material to read, we probably should hear from some other people involved, and so, probably the prudent thing to do is to, just take no action right now and put it on the agenda for the next meeting and hear from experts. Does that sound reasonable? Okay. I don't know if we need any motion to do that.
No, I don't think so. And again,
Okay.
my perspective is, strictly, concern about the county jail, concern about the airport, concern about county-owned facilities. I mean, I recognize that there may be a benefit, economic or otherwise, for drones, and that this may be where our society is heading. If not, we're already there. But my objective in getting you these materials and putting this before you is just to have a discussion about county facilities and what you want to do with regulating these drone devices elsewhere. I think we should have a very, very careful consideration and discussion about.
All right. Yeah, it seems likely to me that the FAA will develop regulations if they don't have them now.
Yeah, there is. If you go to Brian's email to me of August 5, the third page in, Brian provided an overview of small UAS notice of proposed rulemaking with the bullet points. They control airspeed, maximum altitude, minimum weather visibility. It does read, operations in Class G airspace are allowed without ATC permission. I think that's the one that Ross is concerned about. Right there, it's about 2/3 of the way down. Operations in Class G airspace are allowed without ATC permission. Daylight only operations, even has a weight requirement. Must weigh less than 55 pounds. There's I think I read in this article where there's this, right now there's these unmanned, some of these things are huge. You know, some of these things are capable of all kinds of nasty stuff. I mean, the author reads, just imagine what a 50-pound bomb could do at a national event like the Super Bowl or a 4th of July celebration on the mall in our nation's capital. UASs are not easy to detect, and the smaller ones easily could be carried in the trunk of a car, hand-assembled and launched, and programmed to fly to a specific point.
Seem to have that memo by Brian. I can get it from you later.
Okay.
Okay, so I guess at this point we'll move on. Item 3 on the referrals is committee tabled resolution forwarded by Delaware County urging state representatives to amend the New York State Electronic Equipment Recycling and Reuse Act and refer same to the county attorney. He didn't
Well,
have enough to do.
Well, yeah, you know, this is a tough one, and I read with interest how much work Supervisor Strauss put into this, in the Chronicle. And you've got a commanding knowledge of on these, disposal of electronic devices.
Oh, yeah.
And I thought, rather than me, no pun intended, drone on and on about it, that we could, maybe Supervisor Stroud would offer, because if you read the article in the Chronicle, you've done quite a bit of research on this.
Well, it all started when, John Riley, who had, Adirondack Resources, he had an recycling business, where he had left his trailers, he owned them, with our permission, at our transfer stations. And not only was he utilizing the transfer stations of Queensbury, but he had the same process going in the town of Monroe and, Warrensburg, Horicon. And, and he used to make his monies from the tube-type TVs, the CRTs, and he would making like 7 cents a pound, and that covered the operations and gave him a little pocket money, because this was kind of an aside business for him. He had rented a storage facility in the city of Glens Falls. He sorted out the equipment. He would have the trucks pick them up, and they would be weighed, and he'd get reimbursed. And he made, he said, about $4,000 or so a year. Well, when the price for CRTs went from 7 to 0, it just wasn't economical to do that. And he came to my office and he said, I want to tell you the problem, and I may have to pull out because I can't make money. So, so he directed me in, where the legislation was. This falls under the jurisdiction of the DEC. And the DEC has a waste management division. And so I went online, I read the law, and the law clearly states that manufacturers are responsible for the e-recycling or e-collection. That municipalities are not responsible for that. So I called some folks at DEC, and they verified that. And I said to the DEC, and I worked my way up the ladder, I talked to the top guy. They all said that there's problems with the legislation the way it's currently written, and that, and as an aside, I passed that on to Dan Steck, and they said, well, this is something that needs correcting. In any event, I explained the situation to him, and I explained that here we are, we got a problem. And I said that part of our problem is that I can't keep this guy alive, John Riley, alive, because I understand that I can't charge for people bringing in their TVs and their computers and so forth. I can't charge for that. And they said that's correct. It's correct because most of that stuff, they said probably, most of that stuff, if it's on the stream where the manufacturers get credit for it, ultimately, then you can't charge for it. That's part of the provision. So I can't charge for it. I said, so that puts me in a difficult situation. So I can't charge people for bringing in the electronic ware so that I could give this charge to the person who's doing the business and keep it alive. All right, so everything fell apart. So now what do people do? Of course, we got the phone calls and the emails. What do I do with my TV set and so forth? Well, you can bring them to Staples. They'll take computers and computer screens. Ray Supply is taking everything, but Ray Supply is charging. All right. They didn't say that, but they said that's a common practice around New York State. We're aware of it. Didn't sound like the tone of the voice they were pursuing it. The one out that appears that manufacturers have according to the law, is that they are responsible for the collection of it, but there's a clause in the law that says you can mail it to them. Well, who's gonna do that? And DEC, my discussions with DEC, they agreed. We're caught in a conundrum. And I said, well, here's what's probably happening. I said, people are probably smashing up their equipment, so it's not as easily identifiable, putting it in black plastic bags and putting it into the waste stream, which is illegal. Oh, yes, sir, Mr. Stroud, that's illegal. I said, and that's illegal for you to allow that. All right.
Well, now you're getting too close to our responsibility.
Yeah, okay. I said, well, you know, it's impossible to monitor all of it. I scrambled my way out of this. And I said, well, and not only that, but it's likely that people start taking these electronic goods and depositing them in rural areas, you know. And they realized the problem. And what they said to me a month ago was that, okay, well, we are gonna try and link you up with one of these collection agencies. You see, here's another thing about the law. The law says that manufacturers can set up these collection agencies, which will do the collecting of the e-waste for them. And again, they can't charge for this, because the manufacturers are theoretically getting credit for this. And you can't charge for something they're getting credit for at the other end. So, that was a month ago. I haven't heard from them. I do know that the county was trying to say, all right, well, let's put a request for proposal out and see if we can get one of these collection agencies to come in. And that's fine. If they'll come in for free, I guess that'll all be legal. But if we have to pay the collection agency to come in and collect the e-waste, is that legal? Okay. Technically, it's probably not. So here we are. We're caught in a world, it's a catch-22.
Yeah.
What are you gonna do? So DEC folks admitted the law is poorly written, needs to be improved. Like I said. And I've spoken to Betty Little's office and Dan Steck's office about the topic. It's frustrating.
Well, maybe it makes sense to do the RFP to see if any collection agency will come in and do it without charge. If they won't, then let's go for the yes.
The town of Gilderland does it regularly. They have, this agency come up with, tractor trailers, and they fill up, once or twice a year, they fill up tractor trailers full and pull them away. I haven't looked into it, but it's, well known that other communities are collecting these, electronic equipment and, taking care of it. So I don't know why the town of Gilderland can do it, but, you know, Warren County or the town of Queensbury can't. I don't know.
Is Gilderland charging for it?
No.
They're doing it for free?
Right.
Well, that's, you know,
That's how I got rid of a bunch of them.
well, and that's what DEC said to me. They'll try and get me linked up with the collection agency. It hasn't happened yet.
Maybe what we should do is just, I mean, I think it really falls under the purview of solid waste under DPW, that maybe just, that we refer it over to DPW with a request that they try to get.
Julie does have the RFP out right now.
Who does?
Julie Tessina.
Oh, she does?
I saw in my email a while back from her that she has put out, we had to quickly look it over because she was sending out the RFP for the electronics recycling. So we should hear back from that, I would imagine, fairly soon.
Oh, that's right. You're right. Okay. Yes, Ron.
Yeah, I just would, say that, there's no such thing as free. In fact, if, you're disposing of it in that fashion, you're charging the general taxpayer, correct?
Yeah.
So, in effect, that would be a violation of the law, even if you were disposing of it free, so to speak, free with quotation marks, because, that entire cost would have to be borne by, I assume, the general taxpayer. charging for it at the transfer station. John, also, wasn't there correct me if I'm wrong, wasn't there an issue with, the amount of tonnage that was estimated that was sold within certain regions, and when they got to that, what they felt was their quota or their cap, that, was a provision within the law relating to that, and I think that was intended to try to prevent the migration of this refuse from one area to another, and so I think, as I recall, there's also an issue.
I don't recall any cap.
Yes, Frank?
At the NISAC conference, the Committee on Economic Development and Rural Affairs, did pass out a resolution, dealing with this very subject about the, electronics recycling waste law and the problem with it.
That's one thing DEC said to me. They said, Mr. Stroud, you in Queensbury are not alone. This problem has become a statewide problem.
Okay, well, the question for this committee, is there anything we should do at this point? Wait till see what comes back on Julie Pacina's RFP?
Well, and I think in the meantime, we should put some pressure on our legislators to remedy this situation as quickly as possible.
Okay, so you're suggesting like document that there is a problem and requesting the legislature to fix it?
I did that already.
Yeah.
But the more of us that do that and put the pressure on, you know how that works.
Okay, so do you wanna make a motion then that we pass that resolution? Just documenting the problem and requesting legislative.
Yeah, I'll support that and move that we have a resolution to send some kind of language to our legislators identifying the problem and asking them to seek solutions.
Yes.
You second it?
Discussion,
Seconded, Matt seconded, discussion.
just for some clarity. If regular waste, we all take care of it ourselves and pay, but now it's illegal with e-waste to put it in the regular waste to pay, that's illegal. But the manufacturers will take it for no cost,
You're supposed to.
and will they only take the products that they sell? In other words, the brands they sell, or do you have to?
Yeah, that's not clear.
Yeah,
Well, I can clarify that. It is not the retailer's responsibility or liability to take back their own products. It's not the retailers. It's not the municipalities. They told me the law was clearly written to set the burden for the collection on the manufacturers. So a retailer does not have to accept products that they even sold. They don't have to. It's the manufacturers that have to provide the collection.
so the real question is how you get it to the manufacturer.
Well,
Not
they're,
face value,
they're under the law, they're supposed to establish area or areas that are reasonably accessible for this purpose. And I don't think that's very well defined in the law, as I recall. What does that mean? So do we all have to drive down to Albany? Do we all have to drive to Plattsburgh? What do we have to do?
The law does say, in addition to what you said, Martin, it also says it has to provide a collection for any municipality that exceeds 10,000 people. And we exceed 10,000 people, and we don't have it. And we do both the cities and the towns under a mutual agreement. So we're both caught in hard places.
Mark?
I just called the Gilroy Town Supervisor, and he's gonna hook me up with the person that handles that program. I'll get the details
Okay,
on how they handle it for Gilroy.
okay. So just, so you made that motion, seconded, any further discussion? If not, all in favor?
Aye.
Opposed, carried. And we've got discuss increase in minimum wage for fast food workers. I understand the proposal is to increase it from where it is now, 8 something up to 15. Almost double. Committee wanna take any position on that? Doesn't. Yes.
I just think it's gonna have a ripple effect out through all of our other businesses. If you're increasing for fast food workers, there was an excellent article in the Post-Star about Martha's, and what they're seeing as would be an effect for their staffing, so I do think this will have a ripple effect throughout our county, particularly since we have so much service industry here. I think this could be very detrimental for us.
Alright, well, it can affect the municipalities too, if, I mean, I think there's many of the positions we have, like our lifeguards and seasonal workers and parks and rec, not paying $15 an hour. But, I mean, I don't think there's much question the fast food workers are underpaid and, you know, probably should have increases, but the question is, should it be that much, that fast? But, do we wanna take any position at all, or not?
I'm not comfortable yet. I know,
Okay.
I've read, you know, what's been out and available and watched the talking heads, you know, say about the different aspects of what it could or could not do. I think at our level, we should let it play out, see where and what happens with it. And they've identified exactly as you said, there's underpayment being made, and there certainly should be some middle ground, and hopefully through the exercise of trying to get it to 15, which, whether you agree with it or not, should lend something to it, to see where it ends, and we should just continue to monitor, and if we can step in somewhere and add some levity to it, I think that would be more appropriate at this point yet.
Okay, Frank?
I think it's gonna have a ripple effect right back to the municipalities for their union contracts. Because if you got a laborer that's making 10 or 10.50 an hour, and all of a sudden they go to 15, they got a truck driver that's making 20, now the laborer's making 15, the truck driver's gonna be saying, well, okay, where's my raise? I wanna be 25 to keep the separation. Can we get that argument throughout the whole? All the way around.
Evelyn?
This will also, I think, have a negative effect on the Adirondack Park, as long as we're, you know, harking back to that from this morning. If it's already having difficulty and struggling, and largely there's a huge effort to promote tourism and these kind of things in the Adirondack Park, if we're trying to get hotels and places to stay in the park, to keep people in the park, I think you're gonna see it ripple through there, and these are already economically depressed areas. I can't see how it's going to help as it plays out.
Yes, John?
I play around with this idea too, and I'm back and forth about it. You know, and I wonder how many of these people who are currently making $7 or $8 an hour are on public assistance, and maybe if they made 15, they wouldn't be on public assistance. I mean, what is the cost-benefit analysis here? Is this gonna actually save taxpayer monies in the long run? Because it'll take people off of public assistance? I just don't know.
It sounds to me like we just probably don't know enough about the impacts at this point to take any position on it, and that we should wait till there's more research on it before you take any position. Does that sound reasonable to the committee? Okay. Okay, so then we'll move on to referral from the August board meeting, discuss process for tabling resolutions, simple majority versus 2/3 majority vote. Gene Merlino called me yesterday, and he expressed concern about changing it to a 2/3 majority vote. Do you have any opinion on it, Martin?
No, I really don't. I mean, this has been a long-standing practice, for the board. I just, you know, I think it's gotta be really carefully considered as to, you know, whether you wanna change your long-standing practice. There may be some requirements of law that certain things have to be by 2/3 majority vote, some things have to be by majority vote. I think it's something that you really, if you're gonna consider this really gonna need quite a bit of time to delve into and figure out what are the requirements for two-thirds versus what are the requirements for simple majority. And, but I think I think for the most part, I think you can determine your own destiny here.
Right.
But I don't think it's as simple as saying, okay, we're going from simple majority to two-thirds or two-thirds to simple majority. I think it really needs to be carefully considered and debated.
I spent a little time last night just looking at Robert's Rules of Order, and what it said kind of surprised me. It said that the motion to table is designed just to take something away from consideration because there's something more important to do, and that it is misused when it's used to avoid consideration of some topic. And there's another type of motion, it's misused because it only requires a majority, and there's another type of motion which is to remove something from consideration which requires a two-thirds vote. Yeah, so I mean, I think we've always had motion to table this to just take it out of consideration. And that's what I thought it was, but so I was surprised to read that in Robert's Rules of Order. John?
Well, just for the sake of clarification, we're talking about 20 supervisors.
Right.
But when you're talking about majority vote, you're talking about a point system, 501 weighted
Right.
Yeah.
votes.
Right.
Well, that's,
You do have the weighted votes.
yeah, that's the other thing they talked about in this article, that, you know, there's three different versions. There's a majority of the vote of the people voting, and then a majority of the full board, and then a majority of the quorum, which can be, you know, major differences in those numbers. Yeah. And if you go with a weighted vote, you're automatically using a majority of the full board.
The way I heard you just describe it, Fred, was
Yeah.
that the simple majority is to table it because there's more pressing business to do.
Right, right.
Whereas taking it out of
Consideration, yeah.
consideration requires a two-thirds.
Two-thirds, right.
That's a very distinctly different scenario. And what I think Martin gets at the heart of the matter is defining those two scenarios so we know what's clearly simple majority or two-thirds. If in fact that's what this board wants to do, to follow the Robert rules.
Right.
And that's in fact
Yeah.
what we want to do.
And Robert's Rules says that it's, you know, that it's an important power to remove something from consideration so that it should require more than a majority vote. That's the Robert's Rules, as I read it, interpretation. But, do we want to, yes,
I just
Evelyn?
have a question, maybe Martin can clear it up for me. I know, in looking at town law, and I'm not sure how it applies to county, that we don't always necessarily default to Robert rules because there are certain things in town law that, you know, Robert's rules do not apply. Is that similar at the county level as well?
Yes.
Okay.
Mhm.
So we don't automatically default to Robert's rules, we can depend on county law as well.
Yeah, I mean, I guess, and ideally, it would be, maybe ideally, but ideally, if we could get to the point where we define an action, you know, like remove from consideration, table. We already we know that local laws require two-thirds. We know that borrowing requires two-thirds. That's all set forth in law. But if we could somehow maybe do an addendum to our local rules that we adopt every year and say, for this action, when we're at a board meeting and we know that this action is being considered, we all just flip to that page or go on our device and say, okay, Supervisor Strauss, I think that reads simple majority. Do you agree? Right. So we've gotten caught a couple of times in sort of these heated debates during these meetings, and it would be a lot better if we all were just on the same page with these things, in my view.
Ron, and then Mark.
Yeah, I think there are specific provisions where I think it's called supermajority.
Right, there's a list in Robert's
supermajority
Rules. Yeah.
Required, borrowing might be one,
Yeah, it's in our list.
There's a list of things that require, quote, supermajority. And, I've been on the board going on 6 years, always been a majority, and I say that sometimes things get sent back to committee, perhaps they were introduced where they didn't go through committee. They were allowed to go to the board, but when they got to the board, there were issues that came up that weren't considered in committee, and it gets sent back to committee, and,
Well, there could be examples where there's, the main motion is something that requires a 2/3 vote, and then it seems like, at least in that case, you shouldn't be able to table it with just a majority vote, because in effect, you're defeating it without a 2/3 vote.
It's all part of the systems of
Yeah.
checks and balances.
Yeah.
And representation, so.
Yeah.
well, that's kind of what I'm saying.
Yeah.
If you're dealing with a subject matter that requires a 2/3 vote, right?
Yeah.
That's the whole idea behind it. It's a matter that's being handled by a simple majority, gets tabled. I mean, it gets tabled for what, 30 days? I mean, it doesn't go away.
Right.
Sufficient number, but to elevate that to a super majority, I think is, unless a super majority vote is required by statute.
Mhm. So you would be opposed to requiring a 2/3, unless it's
Well,
the main
I
motion
haven't known
requires
it to be an issue.
Okay.
Other than in this one instance. And then
Yeah.
only because the question was raised, whether it was simply a simple question that we had some difficulty with, as to whether it was a supermajority was required to table it, or whether a simple majority, and there's a little confusion there. But other than that, that question
But
being asked.
I think our rules say we follow Robert's Rules of Order unless it's differently stated in our rules. I think, isn't that right?
Provision to that
Yeah,
effect, yes.
yeah. So what I read in the Robert's Rules says motion to table is just if there's more pressing business, and that it's misused when it's to remove it from consideration until the next meeting, and that the motion to remove it from consideration does require a 2/3 vote. So I think that's what we have if we're following Robert's Rules. Yes.
So I think, when somebody motions to table something, they need clarification, and then we need to get it clarified in our rules that, they wanna take it completely off the table or send it back to committee. There's either one or the other. I mean, if they wanna table to get rid of it, it's 2/3. If you wanna send it back to committee, it should be 1/3, but the tabler and the person that seconds, they should be in agreement, I would think, on that.
Don?
Do we have a definition of tabling? When something is tabling, what does that mean?
Well,
Do we defer to?
Yeah, I don't think we have, I know we don't have a definition of tabling in our rules, but I mean, it's sort of we default to the common terminology and dictionary definition, or perhaps the Robert Rules definition. To me, I mean, the most often used time is when something is tabled because we want to get further information, we want to have further discussion, I need time to read something, I need time to research something, whatever the case may
But
be.
does that, if you table it, does that obligate the topic to return next month?
I believe placing it on the table does not eliminate it.
Yeah.
What would eliminate it is
It doesn't
defeat it, or if it was
Not
approved,
defeat it.
right? That would eliminate it from the agenda.
So, then when does it come back?
I've actually researched that in the past, excuse me. If you table it, it stays tabled until a majority vote brings it back from the table.
Yeah.
So in theory, it just sits there, and then at some future meeting, though, a majority can bring it back for consideration. But it never goes away, it just sits there on the table until you do that.
Yes, Mark?
Right, I was just gonna say, I just think it needs to be clarified for all of the supervisors to understand it. Is it Robert's Rules? If so, clearly state, cause that's the first time I've heard what you just said, and
I was surprised to read that.
that's very helpful
Yeah.
to me, cause I didn't know exactly.
Well, maybe what we should do is just get a copy of Robert's Rules. Our regulations, I believe, says Robert's Rules unless we say something different in our own rules. So we just get a copy of Robert's Rules and bring it to the full board meeting, the next full board meeting, and then, maybe have some discussion there and send it back here if necessary. That sound reasonable? Okay,
I've got a copy.
okay. Okay, then the last item is the Safe Act provision which prevented hunting in Pack Forest because it's part of the state school.
Okay.
Want to take any action on this? Yes, Kevin?
Yeah, that was brought, somebody came into my office, brought it to my attention, you know, I think we may have discussed it. They always had a, safety zone up there because it was a college campus. But now with the Safe Act, they've closed the whole area to hunting, and, you know, the locals are concerned about that, and it was just brought to my attention again, and I don't know if, yeah, and I wish Matt was here, because I think they do the same thing in Paul Smith. I don't know if that's a private school or public school, but that was the concern.
Private.
They used to have a safety zone in Pack Forest where you couldn't hunt, but now you can't hunt in any of the lands up there, anything.
Yeah.
That's,
Giant?
I just passed over.
Well, I know that, you know, I used to bring my family and many other families go through Pack Forest and the trails to see the grandmother tree and so forth. I mean, so there is the general public milling around in there, and I'm not sure hunting and public hiking in the same area always mix well.
Mm-hmm. But you said they always had a safety zone, a place. Yeah. Well, do you wanna do anything with this, or just leave it alone?
I'd recommend maybe we talk to Dan Steck and Betty Little, because I don't know, I haven't heard in my town, but we have a large Camp Diptykill in my town, which is technically University of Albany, state school, and there's over 800 acres there, so I imagine, you know, that's probably impacted as well, as though nobody's come in and said anything to me about it, but I'm sure this crops up, in different towns, so maybe we should speak with our area legislators and see what their thoughts are.
Okay. So we'll just take no action on it now. Okay, any other business for the committee? Nat, to adjourn? Made, seconded, all in favor? Aye, opposed?
You know you don't want to